person from Tracker regarding the red polo that has been mentioned by the witnesses. However, yesterday, the state efforts to secure the attendance of this witness drew a blank. But fortunately, today she is available, my lord, and the state would like to lead her evidence first. I've informed my learned friends that we intend to lead her evidence. She's going to introduce a new exhibit. It's the Tracker report that we have marked Exhibit P. Just beg leave to hand up the new Exhibit P. Her name is Miss Maria Elizabeth Pretorius.
Has the defense had an opportunity of studying that report?
Yes, indeed. It was given to them, I think, on Monday, my lord.
That's correct, Mr. Mgumizwa.
That's correct, my lord. My lord, before the witness can be led by the state, I would like to request the basis for introducing this evidence before this court. And which kind of evidence is it supporting? Because in my true recollection, I don't remember any witness talking about the registration numbers of this vehicle. Moreover, my lord, this motor vehicle is alleged to have been driven by Longwe Twala. And why it is the prerogative of the state, of course, not to call him. But what are the intentions of the state to lead evidence that relates to Longwe Twala? The state has clearly stated that they are not going to call Longwe Twala. And this witness cannot prove, in terms of the location of the vehicle, we are not sure about the registration numbers of that motor vehicle.
Is that all?
Why Longwe Twala is not called? The state does not want to advance genuine reasons as to why they are not calling Longwe Twala, being the driver of that vehicle on that particular day. The basis for this objection is that in relation to the movement of this vehicle, it amounts to hearsay, and that the evidence that will be elicited by this lady, especially that deals with the registration numbers of the vehicle, we are not sure whether that vehicle was the one that Longwe was driving on that particular day.
I don't know.
I'm addressing the court so that I'll put it on record.
Fine, yeah.
So that the state can respond from my submissions.
Okay. Mr. Ramsepedi?
As the court pleases, my lord, in as much as the state is dominus litis, I cannot tell the state which evidence to lead. The state needs to be honest with the defense. Yesterday we were informed that this lady will not be coming anymore. And then we are resuming with Colonel Gininda. We want to hear from Colonel Gininda whether he wants to testify during his writing of the exams or whether we stand down until he finalizes exams, then we come back. Now today, to our surprise, this lady is here again. I can honestly tell the court I've never consulted accused number 2 regarding this document for that reason, as the court pleases.
Mr. Mnisi?
That is the same position.
Same position.
When we were meticulously informed that they are unable to get hold by the state, we were informed by the state that they are unable to get hold of a person from the ABL recording company, and therefore be proceeding with this Akinida's evidence. That's what we are expecting to be happening today. Thank you.
Have you heard of the adage that Jesus Christ arose from the death after 3 days?
I'm a Muslim.
Yeah, fine, but
yes.
The Christians and the Muslims know that. I'm saying the Muslims don't know that there's a gentleman called Jesus Christ.
And No,
Never mind that.
Jesus Christ, I don't know him.
You don't know? Okay.
My lord, I'm in the same position. I have
Yes.
not consulted with my client. I was under the impression that Brigadier Gininda is going to be coming. In fact, he gave us assurance yesterday that he was going to be here, so that we resume with his evidence.
Ms. Mshololo?
Same position, my lord.
Same position. Mr. Baloyi, what's your answer to the...
Well, maybe to start with the submission of Mr. Ramusepeli, that the state indicated yesterday that the state was no longer going to call the witness anymore. That is not correct, my lord. We said we couldn't trace the witness yesterday, and that as a fallback position, we're going to call Brigadier Gininda. But we managed to trace that witness, and that is the reason why we're calling the witness now. Now, as regards the submissions of my colleague, Mr. Mgomezulu, firstly, that there's no evidence regarding the registration number. Should that become necessary, my lord, we will lead evidence on that. But he has invited the state to address the court on why the state's intent placing this evidence before court. And for that reason, my lord, we've prepared brief heads of argument that we want to advance. We'll just give a court a copy. But we foreshadow our heads by referring to
As it is the court, I do not intend to stop what the state intends to do. But this is a horrible ambush. The state is preparing heads of argument on what? Who has requested the state to prepare heads of argument? Because once the state is preparing heads of argument, we will also be expected to submit our own heads of arguments. We don't know what these heads of arguments are, whether they need our response or what. Procedure does not.
Yes, Mr.
That's not how the procedure is done.
my lord, Mr. Mgomezulu is inviting the state to address the court on the relevance of the evidence.
All right.
Now we're trying to do that, and now there's an objection. We submit that the defense cannot stop the state from advancing an argument. If they want more time to prepare the argument, they're at liberty to do so, my lord, but they can't stop the state from advancing its own argument.
Yes, Mr. Mnisi, you say you can't stop the state. That's what Mr. Baloyi is saying. From advancing reasons why this witness is being called. Because Mr. Mgomezulu has elicited that information. And now the state says it is responding pursuant to that elicitation by Mr.
When was
Mgomezulu.
that raised, man? When was it raised?
No, but-
That the state needs to explain the basis why this witness been called.
No, but you're not listening. The state says Mr. Mgomezulu
Yes.
says he wants the reasons why this witness must be called. Is that not so, sir?
Indeed, my lord.
And then you say these heads
Yes.
are intended to address that exigence. Wait.
Okay.
Are they intended to address Mr. Mgomezulu's exigence?
Indeed, in fact, if I can just correct Advocate Mnisi, as early as yesterday,
Yeah.
Mr. Mgomezulu signaled his intention to object to the evidence,
Yeah.
and it was on that basis that we prepared the heads.
So you want a ruling on that, sir? Can you stop the state from calling any witness?
That's exactly what I'm saying, my lord.
No,
We
but
cannot.
I'm asking, can the defense stop the state as the dominus litis from calling any witness?
I'm addressing that, my lord. I'm responding to that.
Okay.
That is strike law, man.
What
Whether
is
the
strike
state
law?
would- It is strike law that the state that the state can lead whatever evidence that they want to
Right.
be, whether it is relevant,
Yeah.
irrelevant,
Right.
necessary, unnecessary. whether evidence is there or not there. They can read whatever that they want to read, but there should be a basis for reading that evidence. It is very simple, madam. I mean, if
But Mr. Mnisi, Mr. Baloyi says this is the basis. Sir, are you not saying that?
Yes, indeed.
I'm listening. He says this is the basis, and you are saying there must be a basis. Here is the basis according to Mr. Baloyi.
I'm not saying there must be a basis, madam. I only heard Mr. Ngomezulu today on record saying that the state should indicate the reason why they would want to read this evidence, because the testimony of this evidence will be a continuation of the hearsay about hearsay.
Fine.
I heard him now, but the state already has prepared heads of arguments.
Mr.
When
Baloyi,
are we
sorry.
supposed to respond
Mr.
to
Baloyi
this?
says he was duly advised, or it was intimated to him by Mr. Ngomezulu yesterday that he's going to object to the recording of this witness. That's why he has typed and prepared these hits.
Unfortunately, I wasn't quite privy to that communication. madam. Maybe-
I heard that.
maybe it's an issue
Mr. Ngomezulu, I'm misquoting you. Yet you said
Advocate Baloyi.
we are going to object to that evidence. Did I hear you correctly, Senzo?
My Lord, I've indicated that way.
Yes.
My Lord, there's one thing that puzzles me. It was just an informal discussion between myself and Mr. Baloyi. We were made to prepare. We even listened to Brigadier Kininda speaking. We're preparing for this. If Mr. Baloyi or Advocate Baloyi was intending to serve us with these heads of argument, he could have done that even electronically. It doesn't do that. It
So
can't-
you want time to peruse the hits?
we still have to respond from what he was responding on.
So how long do you need for these hits? There are how many pages? 5 paragraphs, 6 paragraphs.
30 minutes is fine. 30 minutes is fine.
30 minutes. Ma'am, I'm sorry about this. Okay.
My Lord, if I can make a proposal that we go ahead, advance our argument, and if they need time to respond to that, my Lord, they can do so. And Mr. Ngomezulu himself, yesterday when we resumed, he put it on record. It was not a private discussion. He put it on record that he's going to object to the evidence of the person from Trekker. I'm surprised that he says it was a private discussion. It wasn't. It was on record.
Mr. Baloyi says maybe he should lead the witness, and thereafter we adjourn, and if you want to, as you say, you want 30 minutes. Is that okay?
My Lord, I thought he was saying he was going to advance his reasons
Yeah.
for this
But
witness
he
to be
says,
called. Not for this.
as he says he's advancing the reasons. But
Yes.
he also says he should lead the witness first. Am I correct, sir?
No, just advance the reasons,
The
my Lord,
reasons.
and if they want to respond.
Oh, I see. Fine. Okay.
Yes.
Okay. I'm sorry about it.
There's a court, please, my Lord.
Yeah. Okay. Can we start then?
Yes, we are on page 1. We mention, my Lord, that Mr. Ngomezulu has indicated that he'll object to the evidence of this witness, and we then give background of the propositions that Mr. Ngomezulu put to the witness, and under introduction we quote the record. This record, my Lord, are the proceedings that occurred on the 28th of August 2024. He put the following proposition to Lieutenant Colonel Mangena, Mr. Ngomezulu. All right, let me put it, and my Lord, I must apologize, there are a lot of words in these heads that are just fresh from the printing press. We just prepared them shortly before we started this morning. Mr. Ngomezulu, all right, let me put this version to you. According to those witnesses that I do not want to disclose at this stage, 3 shots were fired. 1 shot is the one that caused injury to Zandi on her leg. The other shot is the one that Longwe Twala shot himself on the leg while they were struggling for the gun. The third one is the one that shot Senzo Meyiwa. Says, but I'm not mentioning, then on page 3, I'm not mentioning them according to the sequence of how they happened. I mean, all these 3 shots, they cause injury to Zandi. The one was stuck in the angle of Longwe Twala, and the other one is the one that shot Senzo dead. Then Mr. Mangena, he says, he doesn't know of any injuries to Longwe. Then Mr. Ngomezulu. Longwe, after that incident, that wound became septic, and he went to a doctor, the late Dr. Mbatsani, who referred Longwe Twala to Dr. Modise at Rand Hospital, where a bullet was taken from Longwe's foot. Then we go straight to paragraph 2, my lord. We mentioned that these allegations are so serious as they go to the heart of what is at issue in this case, and they ought to be investigated. And my lord, if AVL or auto vehicle location records can assist the court in the determination of these issues, that it is in the interest of justice that this evidence be allowed. In paragraph 3, we mentioned that automatic vehicle location is a computer-based vehicle tracking system used to monitor the movement of vehicles. It helps to determine and transmit the geographic location of a vehicle in real time. And as we submitted when we dealt with the evidence of Mr. Dupre, said it's eye in the sky. Mr. Ngomezulu says this is here evidence. It's not here hearsay evidence. It's real evidence. It's digital evidence, and it qualifies as real evidence. In paragraph 3.1, we mentioned that the AVL records will therefore show the movement of the Polo, including whether it drove to any medical facility, in light of the proposition that was put to Colonel Mangena that Mr. Longwe Twala shot himself in the foot. And 3.2, in contrast to what Mr. Ngomezulu submitted, we make the point, my lord, that AVL records are independent, objective evidence, and as it were, a silent witness, and we draw parallel with cell phone records, my lord. They're just like cell phone records or bank records. One can surely not argue that cell phone records or bank records are hearsay evidence if there is a witness who comes and give testimony on those records. In paragraph 3.3, we briefly mentioned that a tracking device is installed in a particular vehicle which provides vehicle location information, and a witness from a tracking company, and the witness is now here, would come and testify that in this case she retrieved the information from the system and testify about the period to which it relates. In paragraph 3.4, we mentioned, my lord, that Mrs. Zandi Kumalo, Mr. Tumelo Madala, Mr. Mtokozisi Twala, and to a certain extent Mr. Kai Nashe, inter alia testified about the presence of a red Polo on the premises on the evening of the incident, and that Mr. Longo Twala was the driver. This, in our submission, my lord, renders the evidence reliable and validate the the information that the AVL records will provide. In paragraph 4, we deal briefly with relevance, that the starting point is that all relevant evidence is admissible. We refer to section 210 of the Criminal Procedure Act 51 of 1977, which provides as follows, and we quote, "No evidence as to any fact, matter or thing shall be admissible, which is irrelevant or immaterial and which cannot serve to prove or disprove any point or fact at issue in criminal proceedings." And we then quote the esteemed author Detroit, where he says the following: "Relevance of an item of evidence refers to its logical tendency to show or indicate the material fact for which evidence is offered." And the learned author says relevance is essentially a question of fact, and we refer to the commentary on the Criminal Procedure Act. It's pages 24 to 22b, 24 to 22 to 22. And we mentioned, my lord, that at times a distinction is often drawn between facta probanda, that is now the facts in dispute, and facta probandum, that is the facts that are used to determine those facts that are in dispute. In this instance, my lord, a proposition has been made that Mr. Longwe shot himself in the process of shooting the deceased, and the AVL records would assist the court in determining whether that proposition that was put forward is likely to be true or not. Then interest of justice, we will not deal much with it, my lord. We submit that it is in the interest of justice to allow this evidence to determine the movement of Longwe in light of the version that was put to Colonel Mangena. And we refer to the local classicals of R versus Hepworth. We give the quotation there that the duty of the trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice is done. And we also refer to this case of State versus Sheikh. The reference is given there. We just want to quote what was said there, that the applicant stressed that they place their reliance on the general right to a fair trial, which, as this court has held, extends beyond those specific rights enumerated in subsections 35(3)(a) to O of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach. It is clear also that fairness is not a one-way street, conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused, as well as those distressed by the audacity and horror of crime. We also refer to the multi-choice case, and we give the reference there. We just want to place on record what the SCA held by the current JP of this division, but then the SCA judge, Judge Mlambo, he held as follows: our constitutional court has been vocal regarding the protection of the right to a fair trial. Indeed, any accused person who appears in a court of law facing any charge has the constitutionally guaranteed right to a fair trial, which includes the foundational values of dignity, freedom, and equality, which are central to a fair trial. And they then quoted the case of Zukuza. We give the quotation there, wherein the court held that a fair trial is a comprehensive right and embraces a concept of substantive fairness, and that at the heart of the right to a fair criminal trial and what infuses its purpose is for justice to be done and also to be seen to be done. And finally, we refer to the case of State versus Lameni, Dad and others. We give the quotation there, where the then Constitutional Court Judge Krichler held as follows, that the phrase interest of justice is a useful term denoting in broad and evocative language a value judgment of what will be fair and just to all concerned. We therefore submit, my Lord, that the state should be allowed to examine this witness on the AVL records.
Can interpret.
As a court please. Lapha-ke kukhona-ke okufakwe ummeli kuba uMngomezulu ethi yena ngeke athandisise ukuthi lo fakazi eze azoletha ubufakazi enkantolo. Base kufundwa-ke okwakhulunyiwe ngomhla ka-28 August 2024, and lapho-ke ubaba uMngomezulu ekhuluma no-Colonel Mangena okwavela lapho ukuthi kwadutshulwa kathathu, khona inhlamvu yokuqala yashaya uZandi, enye-ke inhlamvu kuthiwa-ke uShlongwe ethwala wazidubula yena wazilimaza ngesikhathi-ke belwela isibhamu. Eyesithathu inhlamvu kwathiwa yile eyadubula uSenzo Meyiwa, kodwa-ke kuthiwa-ke njengoba kubekiwe kokuthathu lokhu akubekwanga ngendlela okulandelana ngayo. Kuthiwa-ke uLongwe kwahamba waya kuDr. Mbatsane lapho wamdlulisela ukuthi bayomkhipha inhlamvu. Manje-ke lo bufakazi lobu busiza ukuthi-ke kwazi ukuthi imoto yahamba ngoba uma kungavela ukuthize ngokuthi imoto yadlula yakodokotela kuzobonakala ukuthi ngempela imoto yayishayelwa ubani. Manje kuba uMngomezulu ukuthi lo bufakazi obulethwa la enkantolo abone ubufakazi obuqotho, ubufakazi nje obuzwa abantu okuthiwa hearsay evidence isilungu, and then umsheshisi yena uthi cha ubufakazi ngempela lo ngoba kuzokhombisa ukuthi imoto yahamba yaya endaweni la kuthola kunemtholampilo khona, futhi-ke futhi lokhu kuqhathanisa futhi nama-cellphone record. Manje-ke impikiswano-ke lapho ukuthi liyalethwa yini lobufakazi la enkantolo kushushe ukuthi yebo akakhulume usisi lokho emlethela enkantolo, sokuzobeke nempikiswano ngalokho.
Yeah, the defense, do you need more time? If you want to prepare your own arguments on paper, all the better. Because I don't want anybody to say he never had an opportunity to respond to this document. So if you want us to adjourn until tomorrow, I don't have a problem. And then you prepare also a substantive argument.
My Lord, speaking on behalf of Mr. Mnube, I'm ready to respond now from the bar.
Mr. Mngomezulu,
I'm ready to respond from the bar.
Mr. Msipili,
I will also respond from the bar, my Lord.
Mr. Ngumalo,
I will also respond from the bar, thank you.
Ms. Mshorolo,
I have no submissions.
you have?
No submissions.
You must have. You can't be in the air. It's either you are in heaven or on the ground.
My Lord, if we were to look at the procedure, the way things are happening, the application has been brought by the state, then that will mean that the defense will also have to be given time to prepare their
That's it. I want to give you the time if you so want it. But your four colleagues here, they say they are ready. If you say you want extra time, it is your client's constitutional right to insist on that.
As the court pleases, my Lord. If that can be allowed, I'll ask that opportunity, my Lord.
How long do you need? A day? week?
I can prepare my heads tonight and submit them tomorrow.
Ma'am, where do you live? I'm sorry to ask you that. Don't give me the street and the address. Are you living in England or where?
My lord, Krugersdorp.
Oh, you're my neighbor here.
Yes, my lord.
Okay, are you available tomorrow?
Yes, I am, my lord.
Yeah, you heard the argument.
I did.
Yeah, the defense has the right to respond because according to Mr. Mgomezulu, he says they are ambushed.
Yes, my lord.
Labasni, gereeld.
I do understand, my lord.
Okay. Yeah, because of that existence, this court will adjourn until tomorrow.
My lord, if the case is adjourned until tomorrow, my lord, can I ask that I be given opportunity to consult on this document with accused number 5 so that he cannot be taken immediately?
Fine, no problem. Because normally number 5 goes to where he stays at about 4 o'clock. Is that not so?
Yes, my lord.
Where's General Brigadier Ginin? Have you sorted out that thing amongst yourselves?
I have explained.
Amongst yourselves.
Indeed, I've explained that to my colleagues, and I think to afford him some privacy, my lord, if we can address this issue off record, off record, my lord, in light of the fact that the proceedings are carried live. It's an issue that we request that it be addressed in chambers.
You're excused, ma'am. We'll see you tomorrow at 10 o'clock. Okay?
Thank you, my lord.
Sorry about today. Sorry, Mr. Baloyi, you say the record of the, you call it what, an AVL machine?
Yes, that is exhibit that we have placed before.
Yeah, I'm saying you have given it to the councils, all of them?
Yes, on Monday.
All of them, okay, so fine. So you want us to address this issue in private? Why should it be private?
Well, I think someone's studies are, a private matter.
No, I don't like privacy because people talk a lot. They will say we are doing this and this and this in private. Mr. Gininda, Brigadier Gininda, I think, can tell us what he thinks about, and then even the councillors can come in also.
Yes.
And if they think it's not necessary for him to be excused from his studies, that's it.
Well, I've communicated to my colleagues this morning what his preference and request is, my lord, because the court wanted to know whether...
Where is he? Let him come and say it here.
Okay.
I think it should be that way. Okay.
Okay.
Please, is he around?
Yeah, he can be made of... I think if we adjourn for a few minutes,
fine.
he can be here.